Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. I want to remind everybody, hit that like, share, and subscribe button. There's a PayPal button down there for anybody that wants to share some love. And of course, the panel link is down there for anybody who wants to join the panel. We've got John with us tonight. How you doing tonight, John?
Doing good, Keith. Doing good.
Good, good. Sounds like we got Norman Longstaff got our back again. Having success with his phone bill and up there in Canada, and sounds like we're coming together with a lot of these terms and showing that they are not as comprehensible as most people seem to think. They are very simple, actually. So again, another one of those beauties of the English language, that when you get rid of all the twists and turns, things can slow down for you. So tonight we're going to talk about the indemnification part 3 as it relates to U.S. Code 1 evidence. And there's a few sections in here we're going to take a look at that state specifically that, and then go into some legalese type stuff to explain it a little more. So we're going to review that and see what we come up with. First one we got is 1 U.S. Code 112, statutes at large, contents, admissibility in evidence. And it says the Archivist of the United States, this is the Library of Congress, Library of Congress Archivist, shall cause to be compiled, edited, indexed, and published the United States statutes at large, which shall contain all the laws and concurrent resolutions enacted during each regular session of Congress. Concurrent resolutions, this would be both public and private. All proclamations by the President in the numbered series issued since the date of the adjournment of the regular session of Congress next proceeding, and also any amendments to the Constitution of the United States proposed or ratified pursuant to Article 5 thereof since that date, together with the certificate of the Archivist of the United States issued in compliance with the provision contained in Section 106B of this title. In the event of an extra session of Congress, the Archivist of the United States shall cause all the laws and concurrent resolutions enacted during said session to be consolidated with and published as part of the contents of the volume for the next regular session. United States statutes at large shall be legal evidence of laws. Legal evidence of laws. So the statutes at large are not laws. Once again, government shall make rules, or Congress shall make rules for the government. And those rules are merely evidence of laws, concurrent resolutions, treaties, international agreements other than treaties, such as little indemnification contracts, recognizing that we are foreign but domestic to the land, and they are the actual foreign entity. Proclamations by the President and proposed or ratified amendments to the Constitution of the United States therein contained in all the courts of the United States, the several states, and the territories and insular possessions of the United States. So that means all these state statutes outside of the United States, the contents are admissibility and evidence. Does that make sense? I mean, they published it and they're posing it as true and factual in good faith. What do you think, John?
Yeah, I always said that positive law is nothing more than government law, but how much of it is in action?
Exactly. And that action part we're finding out is we have to, well, we don't have to, but it's better presumed that the outcome will be more effective for ourselves and our prosperity if we accept the reality that there's a bond out there that they granted as a nationality. We accept it and then double under her and put that thing in private placement so it doesn't get abused anymore. At least that's my simple concept of it. The next one says 1 U.S. Code 12A, United States treaties and other international agreements, contents, admissibility, and evidence. Secretary of State shall cause to be compiled, edited, indexed, and published beginning as of January 1st, 1950. A compilation entitled United States Treaties and Other International Agreements, which shall contain all treaties to which the United States is a party that have been proclaimed during each calendar year, and all international agreements other than treaties to which the United States is a party that have been signed, proclaimed, or with reference to which any other final formality has been executed during each calendar year. Let's see. There it is. And what we have here is statutes at large and private laws. Enacted bills and joint resolutions appear on this list after NARA assigns private law numbers. Private law numbers linked to slip law text after they have been published by GPO. Public laws are in a separate list. The statutes at large is the permanent collection of all laws, both public and private, enacted during each session of Congress. Now, these private laws that we're talking about are known as private relief laws. See what we can find here. Yeah, here we go. A bill for the relief of James Daniel Bronson. These are evidently from 1980, 1979. So these are just some. We would have to find some more current ones. So let's see what we got. 118th Congress, 2023-2024. No private law numbers were assigned for this Congress. So let's go back. Here we've got for the relief of Arpita Kurtikor, Gurish Kurtikor, and Vandana Kurtikor. Here's one. I remember this one. Relief of Rebecca Trimble. Let's take a look at this one. Private Law 117-1, December 27th, 2022, just about a year and a half ago, says an act for the relief of Rebecca Trimble. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled. So it was an actual communication of Rebecca Trimble with Congress assembled, the House of Representatives and the Senate. So they came up with a joint resolution of a private relief law. You guys understand what's going on here? In general, notwithstanding subsections A and B of Section 201 of the Immigration Nationality Act, 8 U.S.C. 1151, Rebecca Trimble shall be eligible for the issuance of an immigrant visa for adjustment of status to that of an alien lawfully admitted for permanent residence upon filing an application for issuance of an immigrant visa under Section 204 of the Act, and for adjustment of status to lawful permanent resident. I don't like this lawful permanent resident. We would have to find what that is because it's a lowercase. So maybe it would be a matter of defining it ourselves. Adjustment of status. If Rebecca Trimble enters the United States before the filing deadline specified in subsection C, Rebecca Trimble shall be considered to have entered and remain lawfully, and shall be eligible for adjustment of status under Section 245 of the Immigration and Nationality Act, as of the date of the enactment of this Act. Waiver of grounds for removal or denial of admission. In general, notwithstanding in Sections 212A and 237A of the Immigration and Nationality Act, Rebecca Trimble may not be removed from the United States, denied admission to the United States, or considered ineligible for lawful permanent residence in the United States by reason of any ground for removal or denial of admission that is reflected in the records of the Department of Homeland Security or the Visa Office of the Department of State. Remember, it's the Bureau of Consular Affairs of the Department of State. And we're going to be talking about Department of State security. On the date of the enactment of this act, rescission of outstanding order of removal. The Secretary of Homeland Security shall rescind any outstanding order of removal or deportation or any finding of inadmissibility or deportability that has been entered against Rebecca Trimble by reason of any ground described in paragraph 1. Application and payment of fees. Subsection A and B shall apply only if the application for issuance of immigrant visa or the application for adjustment of status are filed with appropriate fees within 2 years after the date of the enactment of this act. So it's a deferment of payment. Reduction of immigrant visa numbers. Upon the granting of immigrant visas or permanent residence to Rebecca Trimble, the Secretary of State shall instruct the proper officer to reduce by 1 during the current or next following fiscal year the total number of immigrant visas that are made available to natives of the country of birth of Rebecca Trimble under Section 203A of the Immigration and Nationality Act, 8 U.S.C. 1153A, or, if applicable, the total number of immigrant visas that are made available to natives of the country of birth of Rebecca Trimble under Section 202E of that Act, 1152E. Approved December 27, 2022. It's a simple private relief law by a communication of Congress at the highest level regarding the Department of Homeland Security as a matter of redress, and it relates to that visa and passport shit. Why? Because it's the Lord that preserves thy going out and thy coming in from this time forth and even forevermore. And they can't admit or deny it. That's an objective truth that every nation firmly believes in. And the only reason for Admiralty Maritime Law is for those merchants. What do you guys think?
Well, I would agree. But greetings, by the way, everyone.
Yes, my apologies. Welcome, Russ. How you doing tonight?
Good, good, good. I see Mitch down in the chat, Norm and them. Good to see everyone.
Absolutely. Norm's got one here. Oops. This one here. Article 1, all freemen, all Indians, all persons bound to service are tax exempt. And we spoke earlier on the phone, and I was telling him how, government instrumentalities are non-taxable. So the instrumentality of applying for a negotiable instrument under the auspices of being a resident or a United States citizen would be an instrumentality of the government and therefore non-taxable. So why are they taxing us? It just, when you learn this stuff and comprehend what it means, you start to question things seriously. So the next one I've got, or actually we got to finish up on this one. It says, the said United States treaties and other international agreements shall be legal evidence of the treaties, international agreements other than treaties, and proclamations by the President of such treaties and agreements. So it's a communication with Congress and the President, just like any other Congressional House Senate resolution. It has to go before both houses, be joint resolutions, and be passed before the President so he can sign off or veto. Therein contained in all the courts of the United States, the several states, and the territories and insular possessions of the United States. B. Copies of international agreements and qualifying non-binding instruments in the possession of the Department of State but not published, and other agreements described in Section 112B 3A shall be made available by the Department of State upon request. Qualifying non-binding instrument. You suppose that's the birth certificate, and it's non-binding because there's no value to it yet. But once you get it as holder in due course from the Department of State, goodness gracious, you are holder with rights of enforcement. Now you can put your value to it for indemnification purposes as a bailment, which we'll be talking about at 9.
And the statutes at large, Keith, I think they describe the birth certificate, don't they? In
Yes.
each state? Oh.
Yes, they should. They should. You should be able to look up birth and death registration with your state codes. Just put Iowa code, birth, death registration, and it should pop that stuff up. If not, just play with the research terms, and it should come sooner or later. It'll help you get better at your research techniques too. So the next one, 1 U.S. Code 112B, United States International Agreements and Non-Binding Instruments, Transparency Provisions. This is where it's been hidden all your life, and now it's holder in due course. If you'll comprehend what's going on, you can be as transparent as you are needing to help them fulfill that obligation of the grant, the assurance of that United States citizenship as a United States business, as a gift, as something you were using as a benefit. A, not less frequently than once each month, the Secretary shall provide in writing to the Majority Leader of the Senate, the Minority Leader of the Senate, the Speaker of the House of Representatives, the Minority Leader of the House of Representatives, and appropriate congressional meetings the following: a list of all international agreements qualifying non-binding instruments signed, concluded, or otherwise finalized during the prior month. The text of all international agreements and qualifying non-binding instruments described in Clause 1. A detailed description of the legal authority that, in the view of the Secretary, provides authorization for each international agreement, and that, in the view of the appropriate department or agency, this is a financial term, appropriate, for appropriating funds, appropriate department or agency provides authorization for each qualifying non-binding instrument provided under Clause 2 to become operative. If multiple authorities are relied upon in relation to an international agreement, the Secretary shall cite all such authorities. This is where that graph of the state's vital statistics jurisdiction we saw from birth registration and birth certificate and death certificate. That graph that shows how it's the birth clerk and the doctor at the hospital, and mom gives birth and fills out that document as an informant, and then it goes to the county registrar, the Health and Human Services, and all those other agencies. Give them all notice. They were noticed when I was born. It goes to everyone, and everyone that was included in my life afterward, the public education system, every last one of them that's holding some kind of record. This is that expenses incidental to transfer of title to agency. And if multiple authorities are relied upon in relation to qualifying non-binding instrument, the appropriate department or agency shall cite all such authorities. Expenses incidental to transfer of title to the United States in preparation for this. All citations to the Constitution of the United States, a treaty, or a statute shall include the specific article or section and subsection reference whenever available, and if not available, shall be as specific as possible. Again, relating to that chart of the state's vital statistics jurisdiction, it is not specific. It is very ambiguous, and therefore it's up to them to determine it, because I'm not qualified of their legal chart and how it all works. It's dependent upon them, and therefore they better be knowing it, because if I have to be forced in labor to contract, to do the research, to show them continuously, then that shows they're not competent to begin with. And again, that goes into the competencies under 5 CFR 575.102. If the authority relied upon is or includes Article 2 of the Constitution of the United States, the Secretary or appropriate department or agency shall explain the basis for that reliance. What's Article 2, folks? Article 2. The executive power shall be vested in a President of the United States of America. The executive power. This is why if you're going to execute your documents, if the authority relied upon is or includes Article 2 of the Constitution of the United States, you have to show the equal station, and therefore, again, the communication with Congress, the communication with the House and Senate, the communication with the President as that process goes. You can't be cut out of the communication anywhere in the process. And again, this goes to the plenipotentiary powers of being able to communicate diplomatically with all of those diplomatic officers. Greetings, Joshua. How you doing tonight? Great to see you.
Good, bro. How are you?
I am well. I am well. What do you got for us? You got anything on this here in particular?
I was really just trying to get this stupid app figured out, so in the event I could interject or ask you questions more directly.
Absolutely. Absolutely. Always appreciate it.
Carry on.
Will do. It says, B, a list of all international agreements that entered into force and qualifying non-binding instruments that become operative for the United States or an agency of the United States during the prior month. This is that amnesty, that armistice in Article 139 of the Lieber Code. They don't have any obligation until you give them notice. So this is a process of giving everybody notice up and down the channels. Principal, notice to principal is notice to agent. Notice to agent is notice to principal. It's an international agreement, not a local contract. Go ahead.
As in the publication, as in the C6 Admiralty procedure, or the Mr. Rice does the publication to end the registered agent of the corporation 3-week publishing, right? Is
correct? That's what
some other ones that pertain.
Yep, that's what I would reference it with. But again, you don't have to publish it in their newspapers or nothing. What you can do is give direct communications to specific agents. Like I said, the mayor, either the board of directors or the county commissioner. If you can get a hold of a county commissioner, that would be the one. But most generally, they refer to a board of directors. So you would just notice the whole board of directors, your state governor, and then of course the president. And this is to get everybody in a line and start communicating as it relates to the Department of State, Bureau of Consular Affairs, as it relates to the diplomacy.
Lawful notice.
Right.
Like a foreign judgment default.
Correct.
Right? At least initiation, because I mean, ideally you get to conducive contracting before you have to default them. But
right, and it would go more relatively, in my mind, as a inauthentic claim, and not one of their inauthentic claims, but mine, because I didn't have knowledge of what their system was. So I made the inauthentic claim, and that was I was a United States citizen and a resident, and therefore subject to the taxes, had to have a Social Security, had to have a job and all that. That was my inauthentic claim. Now that I realize and know better, I have to withdraw those claims. I'm sorry, I apologize. I wasn't competent, nor am I competent yet of the legal system. I do know how to rightly divide the word of truth, and in that, I know it does not apply to me. If we can fix it, great. But if not, it becomes an impossibility, and you can't force that on me. That's as simple as it gets. And again, it's not a matter of contesting their title or office. It's a matter of contesting the record that I faultily entered into. Says the text of all international agreements and non-qualifying binding instruments described in Clause 1, if such text differs from the text of the agreement or instrument previously provided pursuant to subparagraph A2. So again, this goes to that birth certificate already comes with a state seal validating it or authenticating it, and therefore it is a seal of full faith and credit as a contractual agreement with the governor and the state registrar in their federal contracts to acquisition for things in and out of that estate for debts and credits. And that's all it is.
It's an unorganized trust.
Correct. Still a
What's your
trust.
take on the apostille on that? I understand. I agree with you on the authentication that if it's a certified copy, it is authentic.
Right. And the apostille is for visas, for traveling outside of countries. So we find here that you still go to the Senate and House of Representatives to present your private relief bill, a bill of private relief and equity, and that's how you keep everything private. You're going to communicate with these people privately by issuing that private instrument. That's confidential. Nobody's supposed to.
Ways and Means, sir.
Yep, Senate Ways and Means Committee. That's your communication port for equity. It's supposed to remain private. You're the true people that I think we're supposed to be going to for help in this stuff is the Senate and the House of Representatives. So you have 3 people in each state that you should be able to go to along with the governor.
They are the friends of the king,
Yep.
according to Bouvier.
Says the information in text required by paragraph 1 shall be submitted in unclassified form, but may include a classified annex. And that birth certificate and your indemnification agreement are those things. One's going to be unclassified, but the birth certificate itself is going to be classified. Not later than 120 days after the date on which an international agreement enters into force, the Secretary shall make the text of the agreement and the information described in subparagraphs A3 and B3 of subsection A1 relating to the agreement available to the public on the website of the Department of State. And that's going to be the public information available to assure the rest of the public that this diplomat is peaceful and non-combatant, inhabitant, native. Not less frequently than once every 120 days, the Secretary shall make the text of each qualifying non-binding instrument that became operative during the preceding 120 days and the information described in subparagraphs A3, and B3 of subsection A1 relating to each such available to public. What's the difference? Not less frequently. Okay. So every 120 days after that. So this is the quarterly reporting of the receipts and everything that you use, the regular instrumentalities throughout the day to purchase your regular private household good stuff. And then the commander-in-chief shall cause issues or cause receipts to be issued so the spoliated owner may obtain indemnity. So you report all your receipts quarterly with the 1099-C, cancellation of debts. All those receipts will have U.S. debit on it. You cancel the debt every quarter. You remain in communication. The requirements under paragraphs 1 and 2 shall not apply to the following categories of international agreements or qualifying non-binding instruments, or to information described in subparagraphs A3 and B3 of subsection A1 relating to such agreements or qualifying non-binding agreements. International agreements and qualifying non-binding instruments that contain information that has been given a national security classification pursuant to Executive Order 13526. Let's take a look at something else real quick. I believe it's 32, part 156. There we go. I knew I recognized this, guys. I am that damn good. Okay, so what we have here is an international agreements and qualifying non-binding instruments that contain information that has been given a national security classification pursuant to Executive Order 13526. Now, I did a video on this particular section here. Where is it? National Defense, Department of Defense, Office of the Secretary of Defense, Subchapter F, Security Part 156, Department of Defense Personnel Security Program. Remember, we're all qualified, we're all classified upon enumeration at birth as a Medicare qualified government employee. That's the premise. That's the presumption. Resident and United States citizen. It says this part updates policies and responsibilities for the Department of Defense Personnel Security Program, consistent with Executive Order 12968 as amended, Executive Order 10450 as amended, Executive Order 10865 as amended, Executive Order 13526, right there. And then all these other codes. And it all relates to Homeland Security Presidential Directive number 12. Dang it. Let's copy paste that. Pull that up. Paste her there. Homeland Security Presidential Directive 12, Policy for a Common Identification Standard for Federal Employees and Contractors. No one else. Federal employees and contractors. So, no person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board. The board being the Secretary of Commerce as the executive chair and the Secretary of Treasury, where you're supposed to have a qualified contract with an indemnification and surety so that you can contract. That's what the ID and driver's license is all about. It's a license to contract. And there's already an indemnification agreement there, except they're saying that you're the surety. Again, that's a false projection if that nationality was a grant, a conference, an assurance of a nationality to a newborn child that didn't have any parentage. Oh, goodness. Is that inauthentic on that part? Most certainly. It's not a nationality, folks. It can't be. It's a corporate entity. So let's go back. 50 U.S.C. 3161. Let's see what that one says. Oh, goodness. Procedures. Directly related to procedures. Not later than 180 days after October 14, 1994, the President shall, by executive order or regulation, establish procedures to govern access to classified information which shall be binding upon all departments, agencies, and offices of the executive branch of government. Such procedures shall, at minimum, provide that, except as may be permitted by the President, no employee in the executive branch of government may be given access to classified information by any department, agency, or office of the executive branch of government unless based upon an appropriate background investigation. Oops. Where does that background investigation begin? What gives them the right to investigate your background if you're not subject to their code, statutes, rules, and regulations to begin with? It must be a criminal event. That's the only reason anybody would have any reason to check out anybody else's background. Otherwise, you would have to be already involved in some kind of federal employment or contracting to be subject for a background investigation. Thus, such access is determined to be clearly consistent with the national security interest of the United States. So what happens is that enumeration at birth, they provided the United States security interest in the interest of the child. That's what they're promoting as their public safety concern. That's their ulterior motive. However, when that child becomes age and majority, they're still dependent upon that government because they've been indoctrinated to believe certain things, but then that government, being dependent upon them, works against them. because they don't know how it works. Establish uniform minimum requirements governing the scope and frequency of background investigations and reinvestigations for all employees in the executive branch of government who require access to classified information as part of their official responsibilities. It's giving no one else those powers. And here it's limiting them. Upon the exercise of such responsibility, the agency head shall submit a report to congressional intelligence committees. Congressional intelligence committees goes to that 5 CFR 575.102 I was talking about in competencies. Oops, we missed something there. Competencies means the knowledge, skills, abilities, behaviors, and other characteristics an individual needs to perform the duties of a position. So if they don't know this stuff, then what are they doing filling those positions? So let's go back here. Relating to classified national security information or any predecessor or successor order. That's the order for enumeration at birth. Or that contain any information that is otherwise exempt from public disclosure pursuant to United States laws. There is no memorandum of law professing private. That's why we have to come back with these private relief laws. We have to have that communication, because that communication wasn't had at the beginning. International agreements and qualifying non-binding instruments that address military operations, military exercise, acquisition, and cross-servicing, logistic support, military personnel exchange, or education programs, or the provision of health care to military personnel on a reciprocal basis. That's that spell of illness. The rest is talking about food and what else? There shall be a Chief International Agreements Officer who serves at the Department of State with the title of International Agreements Compliance Officer. See, there's all kinds of people we're finding that we have to be in communication with in order to express the trust. And again, we'll be talking about that tonight at 9 o'clock. Bail itself is an express trust. Greetings. Welcome back, Joshua, and greetings, New York native. How you guys doing?
What's up, Apero?
Not much. Trying to help figure this stuff out. You know, my interpretations aren't all that great, you know.
Yeah, well, same here, brother. I'm just trying to figure it all out, brother.
Yeah,
I'm here. I'm here, man.
Did you put a link for that? Sorry, I'm technologically deficient today, and I'm bouncing around. I was trying to point out because I was looking at what are they called? They're supposed to be well, you got councils, and then you have official guests, which is what
Right.
it should be, is official guests.
Yep,
And
I'm traveling at my pleasure as an official guest, touring the nation.
Yeah, and that 58101B is how they got us classified. I'm pretty sure that was on that adventure in my Googling.
So what's the topic that you have going on right now, Apero?
Right now
brother.
we're talking about indemnification as a procedure, a method, and our method is all wrong because we don't know how to communicate it, and that's because we don't know who we're supposed to communicate it with, and those that we're supposed to communicate it with don't really comprehend it quite as much as they should, I think. But what we're showing here is a process where we have a private relief to establish our own law, And it's those that know the law without having to read the law are a law unto themselves. And that's why I'm pointing out these are not laws. These are policies, rules, regulations, and such for government, not the man. The man is supposed to know the law in his heart and be able to oversee that government as an oversight body and not have to get directly involved except to help advise it in the educational forum. That's why I say the people, the American people, having a reading comprehension of about 7th or 8th grade proves that we have a very weak nation.
Okay.
So it all comes down to reading comprehension and communicating with each other.
Okay.
This here, we're talking about the U.S. Code and statutes and everything as being evidence of law. They are not law. It is evidence of law.
Okay. So is this a specific law that you're looking at, or it's
Yeah,
like
this
a
is
general type of
right.
thing?
We're going through the U.S. Code, and right now we're looking at one U.S. Code 112, 112A, 112B, and I think there's a C. I'm not sure. No, just 112, 112A, 112B, and then we're going to look at 204, where we're going to talk about codes and supplements as evidence of the laws. And those supplements are our private relief laws, our private bill of relief in equity. And so we're just discussing how they term it in their U.S. Code. It's the same thing. The law is uniform throughout all jurisdictions. So basically what they're saying is they're going to reiterate everything that you need to know, but it's going to be in different language. Does that make sense? They're going to use different grammar.
A little bit, but by different language, you mean like just different terminology that they're using.
Right,
Okay.
right. Just different grammar and grammar styles.
Gotcha.
So the next one is 1-204, 1 U.S. Code 204. And that is, like I said, codes and supplements. Now, supplements are supplemental agreements, things that we can add to it as supplement to their law, which shows that there's a greater truth. Your laws are public laws, and we have a private side here. So we're going to enter in a bill of private relief and equity, and that's a communication with the House and Senate, Congress, and the President, the mayor, the board of supervisors at the county level, and the governor at the state level. You got to communicate up and down the line, and it's got to be with all of their agencies, officers, and contractors. Everybody that's been taking our data elements and that we've been giving them to, again, that's the inauthentic claim. Not that they've been taking them, but that we've been giving them unknowing what they're used for and how they're used. So it says codes and supplements as evidence of the laws. They are not laws. They are evidence of the laws. Of United States and District of Columbia, citation of codes and supplements. In all courts, tribunals, and public offices of the United States, at home or abroad, of the District of Columbia, and of each state, territory, or insular possession of the United States. The United States Code. The matter set forth in the edition of the Code of Laws of the United States, current at any time, shall, meaning a future reference, together with the then current supplement, if any, establish prima facie the laws of the United States, shall establish prima facie the laws of the United States. General and permanent in their nature, in force on the day preceding the commencement of the session following the last session of the legislation of which is included. Provided, however, that whenever titles of such code shall have been enacted into positive law, the text thereof shall be legal evidence of the laws therein contained. This is what Josh was talking about, positive law, or John was talking about positive law being the United States Code and everything. So this is the public law. When they say positive law, they're talking public law. In all courts of the United States, the several states and the territories of the insular possessions of the United States. District of Columbia Code. This is why I say if the UCC, Uniform Commercial Code, says that the United States is a debtor and that the United States is located in Washington, D.C., then, what is Washington, D.C.? Well, the matter set forth in the edition of the Code of District of Columbia, current at any time, shall, together with the then current supplement, if any, establish prima facie laws, general and permanent in their nature, relating to or in force in the District of Columbia on the day preceding the commencement of the session following the last session of the legislation. So they're tying in that you have to notice both the United States and the District of Columbia. Supplements to the codes, citation. Why do you think they call it a traffic citation? Supplements to the Code of Laws of the United States and to the Code of the District of Columbia may be cited, respectively, as U.S. Supplement and D.C. Code Supplement, the blank in each case being filled with Roman figures denoting number of the supplement. New editions of each of such codes may be cited, respectively, as USC, ED, and D.C. Code, ED, the blank in each case being filled with figures denoting the last year the legislation of which is included in whole or in part. Why do you think they have a separation in the calendar years and the Dewey Decimal System? Do you understand what the Dewey Decimal System does to your math? You might be surprised. So let's take a look for New York natives perspective, since you got in late. This is Congress.gov, statutes at large, and private laws. Have you ever heard of a private law?
No, I haven't actually. No, I got a couple other questions that I wanted to ask, but I'm gonna let you go ahead, brother. I'm listening, brother.
Okay. Well, we read earlier this one here, private law, House Resolution 681 for the relief of Rebecca Trimble, 12/27/2022. So they still do them.
So private law, that goes for what? That's for every individual. That's
every individual has to create their own private law.
Single-handedly, pretty much.
You have to let them know that you're competent of what's going on. You know how the system works. You know how to be diplomatic. You know your plenipotentiary powers and how to assign them in trust through proper contracting.
Okay. So, all right, real quick. I'm sorry, Battle. So, is this oh my God, I'm trying to find the right word for it. But considering, is this for people that are consider themselves sovereign citizens, or is this for every citizen? Okay, go ahead, brother. I'm sorry.
Yeah, this is for everybody because it's a matter of correcting the records. It's not a matter of whether they consider themselves a sovereign citizen or anybody else considers them sovereign citizen. Those are mere definitions of language that have nothing to do with contract or trust.
Okay. I'm just trying to meet you.
Right. Well, you have to remember that trust operates in public, but in that trust, the contracts themselves have a element of privacy. That's one of the first basic elements of contracting. Your right to contract is that you have a right to contract privately with one other man without a third-party interference. And that's all we're doing is learning how to contract through a bailment by placing an indemnification contract forward, saying, hey, we won't really know all of your contract terms and conditions, but hey, if we fuck up, we understand full faith and credit is allowed, so here's the indemnification. We're just generating the path to the credit system that allows full faith and credit.
Okay.
And I think you're on to something with 19 in the code 19, as far as when you get to this point and being able to use letters of credit and stamp duty, cancel stamps. I don't have the code. I sent it to you once, but I'll find it. I'm sorry. It is in the USMCA and operating under the free trade agreement.
Right. And it all goes to a video I did a while back. I looked up every last one of these, and They're all executive orders, public law, and 5 U.S. Code 301. This is the main one that caught my attention because I understood 5 U.S. Code 301 is where the enumeration at birth has its minimum birth registration requirements. Let me look it up, and I'll show you something.
Okay. So I'm not sure if this is on subject or off subject. Like, so how do you feel about, identification cards and, driver's licenses and stuff like that? Like,
You should be able to travel
travel.
diplomatically with diplomatic credentials, private credentials, showing that you
Okay.
are diplomatic. You are a true believer in the truth, and that you assure that everything you do is truthful. This is a grant and diplomacy. That's why they gave you a diploma. They profess that you have diplomatic skills, that you can go forth and believe in the truth because you can profess the truth as best and clearly as you know.
Right,
And
but they
nobody,
only give you that. They only give you that diploma when you graduate high school.
correct.
Only high school. That's the only time you're given that diploma. So when you graduate high school, that's when the society or government at hand determines whether you're an adult, pretty much.
Right. It's an age of majority that
Okay.
that professes that you're a man now, and you've been taught communication skills, you've been taught the truth, and you've been taught civilly how to behave with other men. And that's a basic concept that generally should be true, but we've never been taught to the modern language of contract, and that's the problem. The twisted English language in legalese and contracts has become so contorted, and the public education system doesn't teach us concise English. They teach us a basic form of legalese, wherein they teach you at 5 years of age to read and write the legal name, and never grammatically express the given name with the surname, which is with hyphens and colons. They've never taught anybody that. You go to the Amish schools, that's what they teach. And it's a distinctly different grammar.
Okay.
Greetings, Brother Keith.
Greetings. How you doing, India Maria?
I'm well. Thank you for asking. How are you today, Brother Keith?
Good, good. Now I want everybody to realize this is 5 U.S. Code 301. 5 U.S. Code, government organization and employees as it relates to the Department of Defense personnel. Part 1, the agencies generally, powers. Section 301, departmental regulations, and this is directly from the government publishing office. It says the head of an executive department or military department may prescribe regulations for the government of his department, the conduct of its employees, the distribution and performance of its business, and the custody, use, and preservation of its records, property, or papers, and property. This section does not authorize withholding information from the public or limiting the availability of records to the public. The words executive department, all the way through, and we go down here, and it says, this section was part of Title IV of the revised statutes. The Act of July 26, 1947, Chapter 343, Section 201D, as added August 10, 1949, Chapter 412, Section 463, Stat 579, former
I'm
5
sorry,
U.S.
real quick.
Yep.
You know what happened? You know what else happened in 1947? 1947, Area
Right here.
51. Yeah.
Oh, yeah.
I'm sorry.
Yeah.
It was there, bro. It was there. I just had to.
Yeah. Was that the same day? Was that the same day?
Oh shit. As far as the day, I'm not sure, but year, yeah, you're on it.
Yeah, we'll have to check
Same
it
year.
out. So it says
1947, Area 51, brother. I think it was August or July. I think it was around that time. I'm
we'll have
I'm
to
not
check
sure
that out.
of the actual date. We'll have to check it. I'm sorry, I didn't mean to cut you off, Super.
No,
For
no,
real,
that's all
bro.
right. But the point here is, notice it says right here, except to the extent, this is a quote, inconsistent with the provisions of this act, National Security Act of 1947, the provisions of Title IV of the revised statutes as now or hereinafter amended shall be applicable to the Department of Defense, is omitted from this title but is not repealed. So it still
Yeah, I just
says,
looked at it. It said July of 1947, brother.
okay.
Yeah.
So when it talks about the departmental regulations, these departmental regulations are applicable to the Department of Defense. It doesn't say it's applicable to any other department or office or agency or anything.
Mm.
Okay? It says is omitted from this title, but is not repealed. So it's inclusive here, even though it's not mentioned. Okay? Then it talks about the plain writing in government documents. And
I
it
think
is
it's
in,
crazy that they have all these documents and all these things, right? That they give to us, and then like in the documents, these words have several different meanings. So it's like it's really hard to comprehend sometimes, man. Like,
I agree. But we look at this and check this out, guys. It says plain writing in government documents. This is a government document. And even though it was omitted but not repealed, they included it in a quote. So it's right there in plain writing. All you got to do is read it. It's applicable to the Department of Defense. No one else. You were born in a military hospital. You went to a military school. Those are military colleges. It's a military government. And martial law chiefly affects the police and the collection of public revenue and taxes. And it's for the Army, its use, its safety, and the safety of its operations. Nothing else. And it has to be required first. They can't just go wantonly taking shit. Then,
For officer safety.
yep. And notice these are all youth organizations under the military. Boy Scouts is military. Girl Scouts is military. Boys Club is military. Girls Club is military. Young Men's Christian Association is military. Civil Air Patrol, all military. United States Olympic Committee, military. Special Olympics, military. My God.
What site do we find this on, Brother Keith? Where's
This is 5 U.S.C. 301. And you want to look at the govinfo.gov site.
okay? Thank you.
Not the Cornell. Normally I go to Cornell, but Cornell doesn't have this except in notes and stuff. This one has a straight up document with all of it. Minimum standards for birth certificates.
So, Brother Keith, right now that we're talking about birth certificates, I just joined the panel, but what happens when someone holds dual citizenship?
What do you mean? Like resident United States citizen?
No, born in another country, but you become a U.S. citizen here.
Oh, the
So you,
naturalization. The naturalization is does the same thing, with the exception of in the United States, the American people that are actually born here have a public education system that has wiped out civics, whereas the naturalization of immigrants requires a civics class that they have to pass in order to become naturalized. You remember passing that civics class?
yes.
We don't have it. You actually have a greater advantage than we do.
What?
Yeah. So it says, A, definition. In this section, enacting this note and repealing provisions set out as note below, the term birth certificate means a certificate of birth for an individual, regardless of where born, who is a citizen or national of the United States at birth, and whose birth is registered in the United States. Now, let me show you about an inauthentic claim, folks. It says, whose birth is registered in the United States in plain language, correct? Can I get an amen from everybody on the board?
Amen.
Okay. I'm going to
Amen.
show you. Everybody sees my Google screen here. Is there a birth certificate in the United States? American Bar Association birth certificates.
So our birth certificates are considered as what? Super.
It's
In
called a
layman's terms, brother. I'm
it's a
sorry,
bail
bro.
it's a bail bond.
Really?
Shit.
In the United States. Read again, folks. Read again. Let me go back
Yeah,
here.
yeah.
Let
Go
me go
ahead, bro.
back
I'm
here.
sorry, man.
B. Minimum standards for birth certificates. B. Whose birth is registered in the United States. American Bar Association, a decentralized system. In the United States, there is no national federal birth registry, as you might see in other nations, such as the United Kingdom. Instead, birth certificates are issued by the states. So I want to ask you, is there a birth registered in the United States?
No.
I would say yes.
It just said there is no federal birth registry in the United States. How is there a birth
Wow.
registered in the United States?
Damn. So I guess not.
It's an impossibility.
Am I the one that's misinterpreting this shit?
Right.
Or am I
No,
just
no, no.
showing the inconsistencies in plain writing, which is a requirement for government documents that show it's impossible for them to bring forth a record of anybody whose birth is registered in the United States? They don't even have proof of it. Yet everybody's going around claiming, I'm a United States citizen, I was born in the United States, and there's not a single proof of it.
So what does that mean for all of us? For everyone else? What does that mean for
That
all of
means
us?
your whole life's been a lie.
So we're not citizens at all of this country.
Brother Keith,
Absolutely not.
Brother Keith, I understand a lot of this so far. What I'm having a problem comprehending is how does someone do, okay, because I hear a lot of people where some people denounce, one of the citizenship as opposed to the other one, and some keep their dual citizenship. So in this case, how would you go about fixing the record?
Again, going through and showing them the errors. I'm sorry, there are two very simple errors. I'm not a resident, and I'm not a United States business. However, I do have evidence. However, I need to supplement it with my own private indemnification as a private bill of relief, establishing my own private law.
Okay. Ooh.
Okay, so
It's a lot. It's a lot.
So very simply, that nationality that was conferred upon you at birth,
Right.
Jeremiah 1:5, before I formed thee in the belly, I knew thee, and before thou camest forth out of the womb, I sanctified thee, and I ordained thee a prophet unto the nations. So what they've done is they've used national or local ordinances to sanction the word of the man that was discharged from his mother's waters and became a living soul, and instead recorded him and entered him into a manual existence of a record with a name and a number, conferring that you are of the nation and not of heaven. We are in this world, but not of this world. Then we look at Psalms 21, from that time forth, as a prophet unto the nations. The Lord, Psalms 121:8, the Lord shall preserve thy going out and thy coming in from this time forth, and even forevermore. And that is for the intent of being a stranger and a sojourner with him, as the land shall not be sold forever, for the land is mine, for ye are strangers and sojourners with me. And in all the lands of your possession ye shall grant a redemption to the land. That's your duty, and you grant a redemption. You are the grantee. He gave you possession of the land. It's in your possession. You now have the grantee position. And that grant is a redemption for the land. Then, coincidentally, it says, if thy brother be waxen poor and hath sold away some of his possession, and if any of his kindred, kin, image and likeness, come to redeem it, then shall he redeem that which his brother sold. We're not supposed to be buying and selling. We're supposed to be redeeming. Does that make sense?
Certainly does to me. Do unto others as you'd want them to do unto you.
Love thy neighbor as thyself.
Absolutely.
And again, I profess that the true knowledge is the true benefit. That's how your cup welleth over. We keep teaching our kids in these public educations the dogmas of all the different teachers that they encounter, as well as all the other students that come from different cultural backgrounds, instead of teaching them our own cultural background and what it means to keep your house in order. Be respectful and fearful of the Lord, knowing that he is always our oversight. And in that, as his trustee, we are supposed to be the oversight of the government. How can we do that without knowledge? Sole procedure, AG has an oath of allegiance or they don't. Any court with law and equity can do a de novo review. Yep. International Bill of Exchange. Well, yeah, that's that Securities Exchange Commission document we showed last week with the James A. Williams Trust. It was an indemnification, and it showed that it was a promissory note, indemnification, letter of credit, international Bill of Exchange. It encompassed all those concepts. And like I told you, Native, it's a bail bond. It comes in bond form, and you can use it to bail through indemnification. We're going to do that at 9 o'clock.
Oh my gosh.
Yes. If you take benefits and privileges, you are actually contracting as a U.S. citizen in the public. And that's the problem. You're not supposed to be. You're not competent to be contracting in those government contracts.
And Brother Keith, I have heard of people working both, the private and commerce.
Yeah, if you know what you're doing. I wouldn't recommend that as startup. I would recommend a developmental process.
Okay. Yes, I agree.
And your safest is developing that or understanding how that trust works, and that it's already there and they've already breached it. Now it needs to be collapsed and reconciled so you can transfer the property accordingly for its commingling. The beneficiary has a right to follow trust property when commingled. Harvard Law Review.
Does that mean when they make, someone a U.S. citizen, another bond is created?
Right. That's the initiation through the spell of illness at the hospital on the first day, where you're providing inpatient hospital services or treatment. And the treatment is a pre-treatment standard that you have to have a birth certificate. It's required. No, it's not. That's applicable to the Department of Defense. Well, you were born in a military hospital. Then you consumed it or continued it with minimum state contacts by keep going back to the doctor instead of using homeopathy and other things, natural health providers, and public education. That's military.
Yes.
You know, you continue on in the military forum.
They commit so much fraud. I remember my firstborn.
No, we can't call it fraud. We call it inauthentic claims, both by us and by them.
Inauthentic claims. They did my firstborn son. I remember I lost his BC a few times, and the last time that I went and picked it up when he was a minor, of course, they had switched his name, and this is long before I became awake. They changed his name. I had given him a name in Spanish, so they changed it to English, and they removed his middle initial, his middle name, excuse me. And I never understood that. I used to always wonder, how did you do this? And they wanted me to go to court to change it back. And I said, no, you guys have the form that I filled out at the hospital, which, has his name in Spanish. They changed it to English and they removed this. So does that mean he too has 2 birth certificates out there?
I don't know.
Huh.
All I know is that once you order them from the state, you are holder in due course, and you have the right to enforce them. It's a matter of knowing how to enforce them, and that's by contract. In that contract, you're stating you're a third-party beneficiary that's got to qualify a contract for indemnification because of the record. The record has shown that it's caused you harm, but you can't call it fraud because it was an inauthentic claim by yourself. Had you known the information, you wouldn't have made that claim. Therefore, you didn't do it in fraud, and neither did they. Okay. However, once you give them notice and they ignore you, now you can get them for misfeasance. If they ignore you again, you can get them for malfeasance, which is fraud.
Okay.
Breach of contract, breach of trust, both. But again, it takes that competency to understanding the trust and contract, how they work, and their part in it versus yours. It is comprehensive, but again, like I said, it's already there. The trust has already been expressed. You just have to recognize it. And we'll talk about that again tonight with bailment.
Got it. Thank you.
All right. Greetings, Sister Iman. How you doing tonight? Iman.
Yes, brother.
There you go. How you doing tonight, sister?
Still here, hanging in. All is well.
Good deal. Good to hear. We're just finishing up, so we're on our way out. But like I said, we'll be back at 9 to go over bail and bailment and stuff. You guys got anything on the way out?
I'll just go with what I always do, brother. Wish everybody would be the change you wish to see, and always remember, popularity without a positive purpose is pointless and valueless to life. There's a whole lot of people out there are dependent on a lot of people in this movement here, or whatever the hell you want to call it. But, I love what I continue to see on this platform for sure. And Keith, I believe you're pretty authentic, my friend. And, keep doing what you're doing, brother. Straight is the gate and narrow is the way.
Absolutely.
Much love and many blessings.
You too, brother. We'll see you later.
See you at 10, 9, whatever it is.
Yep. What about you, India Maria, Josh? Anything?
See you tonight at 9.
Absolutely. I'll be there.
Thank you, Brother Keith. Can see you later.
All right. All right. You guys know me. I love you, but I don't give a rat's ass whether you love me back. That's to say I don't care if you don't respect me or if you hate me. That's on you. So may God bless you, and we'll see you later. Bye now.